Good morning, and thank you for joining our webinar workshop on enforcing adjudication claims brought by insolvent companies post-Bresco. I wanted to say Brexit. I wonder why. Okay, background. We all know that in Bresco, the Supreme Court in the middle of this year took a different approach to the TCC and the Court of Appeal and ruled that adjudicators do have jurisdiction to decide disputes brought by insolvent companies, and that allowing such adjudications to proceed was not an exercise in futility. Some of us in this session considered the implications of that decision in a webinar, which is now available on the 39 Essex website. Like many others, we speculated that the debate and the issues were really going to be thrashed out at the enforcement stage, because the Supreme Court plainly flagged up that that was the point at which insolvency and its implications was to pinch. So it didn't take long. Last week, Mr. Justice Fraser, who had of course been involved in Bresco at first instance, has given us the first significant decision indicating the approach the TCC will now take. John Doyle Construction Limited in liquidation and Erith Contractors Limited. We've pulled together at 39 this panel. It's not a manel, it's very much a panel. You have me, Marion Smith, speaking, and I'm joined by three members of 39 who have experience in a broad range of international and domestic arbitration and litigation, but specifically a wide experience in adjudication and adjudication enforcement, taking them as the bar does in the order of call, which means that your age is forever out there. John Dennis Smith, his adjudication experience involves payment disputes, fraud allegations, professional negligence claims, as well as proceedings where the financial standing of a party is in dispute. David Sawtell, his adjudication experience is infrequently involved in the development and use of land, buildings and property, as well as matters involving serious insolvency and company law issues. And his work, like John's, they both have an international edge involving cross-border and overseas transactions and disputes. And then Rebecca Drake, who too is instructed in high value and complex construction disputes, and her adjudication experience ranges from quick payment disputes as sole counsel to complex matters involving teams of experts. She acted as sole counsel in the recent decision of Rochford and Killane, which created new law on the final date for payment. Rachel prides herself on her written advocacy. I think all of us would say that oral advocacy is what the English bar is noted for. Rebecca points rightly to her written advocacy. She explained to me that the opposing referring party withdrew its claim less than an hour after receiving the response she'd just drafted in a recent adjudication. So against that backdrop, this is a workshop. It's Friday. It's a practical subject. We want to talk about the implications and advising. So we have, thanks David, he's drafted a very cunningly nuanced problem. It has been circulated to all of you by email. You may find it useful to get it up now and to have a look and to think about it, because we're going to pin our debate on that. What we're asked for, I think, as lawyers increasingly, is for our gut feeling right at the beginning. What's your gut feeling about that? And you get that through experience. And we're hoping that this experience will improve all our guts, just like the advertisements say. So, Rebecca, question number one, you're going to kick us off. What are the appropriate directions for the TCC to make? And initially, let's put that into context. We know that Sparky are seeking the usual speedy directions towards summary judgment.
And this was the subject of the final two paragraphs of Mr. Justice Fraser's judgment in Erith, the paragraphs 146 and 147. He referred to the fact that the TCC has developed a streamlined and rapid procedure in adjudication business for abridging time, for acknowledgement of service, serving evidence, and the other necessary steps. Usually, as you'll all be aware, the time limits for these steps are very tight, with a hearing being brought on before a judge, usually within 4 to 6 weeks. Now that obviously matches the spirit of adjudication, intended to give parties to construction contracts quick answers to disputes, often while the work is still going on. However, he said that that procedure was not required or suitable for summary judgment applications such as the one in Erith. In that case, the works were performed between 2010 and 2012, which was also the origin of the dispute. The liquidation occurred shortly afterwards in 2013, although the adjudication itself wasn't commenced until 2018, with the hearing for enforcement taking place in 2020. He said that when enforcement proceedings relating to historic claims are brought by companies in liquidation, the defendant may need time to organise its evidence. Relevant employees may have left, and there may be a need to locate relevant documents. He said that in cases such as those where there's a historic dispute, the normal timescales in the CPR are likely to be more appropriate. So hearings will take place in a number of months rather than within a few weeks of issuing the claim form. So it's not the timescale we're looking at for a full-blown trial, it's the normal summary judgment timescale, so a few months rather than a few weeks. And he said this would have two advantages. So the first is enabling a defendant to meet the claim for summary judgment fairly by being able to access relevant evidence. And secondly, preserving the fast-track process for solvent parties who are in urgent need of a decision from the court on either a more contemporaneous or a more pressing dispute. And so while he said that changes to the TCC guide would need to be considered and perhaps formally made following the decision in Bresco, parties in a similar position to that of John Doyle shouldn't expect their claims for summary judgment to be routinely expedited. Now, obviously, the facts are different here. The timescales are much shorter and there's less time that has elapsed. But there's still a number of years since the events in question. Sparky entered liquidation in 2017, some years ago. So we think that it would certainly give employer co grounds for an argument that the expedited procedure should not be used. Now, in terms of the substantive decision that the court has to reach, there are two routes effectively to the same end. The court can either refuse summary judgment or allow summary judgment but order a stay. And we'll take refusing summary judgment as logically prior. At paragraph 54 of his judgment in Erith, Mr. Justice Fraser set out 5 principles, or 3, depending on how you look at it, to be applied by the court when considering an application for summary judgment on an adjudication decision in favour of a company in liquidation. I'm going to go through these briefly, and then David, John and Marion are going to apply these to the facts of the case. So the first principle is this: whether the dispute in respect of which the adjudicator has issued a decision is one in respect of the whole of the parties' financial dealings under the contract or simply one element of it. The next 2 principles, 2 and 3, can often be considered together. Number 2 is whether there are mutual dealings between the parties that are outside the construction contract under which the adjudicator has resolved the particular dispute. And thirdly, whether or not there are other defences available to the defendant that were not deployed in the adjudication. The next 2, 4 and 5, can also be considered together. Number 4 is whether the liquidator is prepared to offer appropriate undertakings, such as ring fencing the enforcement proceeds, and or whether there is other security available. And 5 is whether there is a real risk that the summary enforcement of an adjudication decision will deprive the paying party of security for its cross-claim. David, John and Marion are going to have a look at these points, and then I'll come back after that to the second route of preventing the insolvent company being awarded its money, which is the question of whether or not a stay should be awarded.
So let's go on to question 2, because the parties in this problem question, as carefully contrived, have clearly had a number of mutual dealings. They, as is often the case, they've been involved in a number of projects together, building a series of 3 retail parks. And Sparky's decided to go for, in some ways, a more straightforward one, applying the Bresco principles. As a final account dispute, everything has come to a head. And if this was the only contract that they're involved in, it might be seen as the most straightforward path to try and secure enforcement applying the Bresco principles. But that isn't the end of the problem question, because they're involved in 2 other disputes. One, Retail Park 2, there's been intimations about defects with Sparky's work. Well, Retail Park 1 is even more complicated. That seems to have all finished. The retention's been paid, but Employer Co now thinks potentially it might investigate a claim against Sparky. And this is a problem which is exposed by cases such as John Doyle Construction and Bresco and other cases. We have the issue of insolvency set off, and it's a very valuable defense for a company facing a claim against a company that's insolvent liquidation. They're entitled to set off the entirety of their set off pound for pound against an insolvent company's claim, whereas if they had brought it individually as a standalone claim, they'd only get pennies in the pound in distribution. And that is part of the Insolvency Rules 2016, Rule 14.25. That's slightly different for administration. For administration, you only get insolvency set off where the administrator is proposing to make a distribution. Only then do you get the rules kicking in at 14.24 that engage insolvency set off. And this incompatibility with adjudication was recognised as long ago as Dow Jensen and Bowie in the Court of Appeal in 2000, because adjudicators can only deal with one dispute at a time, and that was clear. And in Bresco, there are some suggestion from Lord Briggs, adjudicators might be able to deal with more, but would only be by way of consent. And as Justice Fraser in John Doyle warned adjudicators against broadening out adjudication to take on more than one dispute. So the existing case law on the scope of a dispute remains intact following John Doyle Construction. So what you need to do is bring all of these disputes to a head. And that's what Mr. Justice Waxman did in another decision this summer, Balfour Beatty against Aztec Projects Limited, brackets, in liquidation. And again, note all these cases are liquidation cases. There were 3 contracts, eerily similar to the problem question scenario. And as a condition of getting enforcement, the claiming party, the company in liquidation, had to give an undertaking to bring the other remaining 2 contracts to adjudication. So that way, you've got all of the mutual dealings all dealt with together. So that's fine. In this case, Retail Park 2, you can see that Sparky will be willing to take that to adjudication. But Retail Park 1 is going to be more problematic. They don't even know there's a dispute. No dispute is even crystallized because it's not been intimated to Sparky. So the ball is really going to be on the side of Employer Co. What do they do with this? Do they intimate a claim now? But then we have to decide whether issues of limitation, if this was a simple contract, rather than by one of under seal. So there's going to be a lot to do if we're going to try and raise it. And really, I think it's something that you have to advise quite carefully, Employer Co, on how they want to pursue it, because after all, they don't want to incur unnecessary costs if it's simply going to be a poor claim. I've mentioned conditions. I think I'd like to hand over to John to consider more specifically the question of conditions.
Okay, thank you, David. So first of all, let's get the starting conditions right, because if you're in the position of advising Employer Co, you want to remind the court of the conditions. The first point is that the conditions have to place Employer Co in a similar position to the one it would have been in had Sparky been solvent. And that's a point made in the John Doyle case, and it cites the decision in Medicide Building, the earlier decision, which will introduce us to ring fencing. So that's the starting point, and there are 2 elements that have been offered on behalf of Sparky. There's ring fencing and there's an after the event insurance policy, the ATE policy. So let's consider them in turn. First, ring fencing in principle has been commented upon as something that could be acceptable security so as to justify enforcement by the court. There's a comment, and you'll find in John Doyle that this is referred to by Lord Briggs in the Supreme Court in Bresco itself. And it's the same point is made at the very end of the decision in John Doyle by Mr. Justice Fraser. That was all about liquidators, and the instance that we have of an enforcement on that basis is also a case about a liquidator, and that's the Medicide case itself. And in that case, there was an undertaking that had been given in witness evidence by the liquidator that they would ring fence any sums paid for a period of 6 months. And if the defendant were to issue proceedings within that period to overturn the decision, then it would continue until those proceedings were concluded, and they would then repay the monies to the extent that the defendant successfully overturned the adjudication decision. And that was held in principle to be adequate, although as you'll hear later, that didn't lead to enforcement. There were other things in play. But there isn't a decision yet about how such an undertaking is to be implemented. There was a reference to the principle in the Balfour Beatty case in Aztec, although if you blink, you'd miss it. It's paragraphs 28 to 29 for those who want to find it. But the main focus was elsewhere because that was a pre-Supreme Court post-Court of Appeal Bresco decision. So you need to look at what's actually been offered. And the starting point here is that the offer has actually not been made by Sparky's liquidators. The offer has been made by the funder, Calculus. Now, Calculus might be a wonderful body. It might be a member of this institution known as the Association of Litigation Funders, and they have a code of conduct, which you can find online. But they're still not a liquidator, and they don't owe the duties that a liquidator owes. So the starting point is that you might argue for employer code that an assurance by someone other than a liquidator isn't the same, by analogy with the rejection of the letter of intent that was an issue in John Doyle. And that was from the bank. That wasn't considered to be good enough. So the first point is that ring fencing has been offered by arguably people who can't really be relied upon in quite the same way as a liquidator would do. Then there's the question of the lien, which we're told about. And the lien seems to be in favour of insurer co in relation to the enforcement sum. So there's a question mark as to whether the money being placed in a separate account is going to be for the potential benefit of employer co alone. So the first point to do is to seek information about calculator standing. How much is an undertaking for them actually worth? Is it equivalent to a guarantee or a bond or not? And if you look at Meadowside, you'll see that the test there was whether a guarantee would provide a high degree of certainty that the guarantee will be called successfully. So do you have that high degree of certainty? Second point, insist that Sparky's liquidators give the undertaking. And you need to ask about the mechanics for ring fencing and how the lien fits with that. You also need to find out what the period is going to be, because at the moment they've said they'll ring fence, but they haven't said for how long. And Calculus might offer for 6 months. In Meadowside, Adam Constable QC, who decided that case, said that 6 months may well be appropriate, but he made the point that it might not be enough in some cases. So one has to have a discussion internally as to how much time employer co would need to get to the point that it really brings its claim. And in any event, the final point on the ring fencing is that's only about the adjudicated sum. So it doesn't cover costs such as adjudicators' fees, enforcement proceedings, and subsequent litigation. So that's where one looks to the ATE policy. Now, again, go to the test first of all. The test is whether the policy provides sufficient protection. That term is at paragraph 104 of John Doyle. You'll see in that passage of John Doyle that there's a reference to a Court of Appeal decision, Premier Motor Auctions, and quite extensive consideration of what's said there. So the first thing you need to do is actually get the ATE policy. The second thing you need to do is see what the scope is. What costs does it cover? Does it cover all the sorts of costs that you think might be generally in principle coverable? Does it contain limitations? Does it cover any Sparky's costs to bring a claim? Not defending a claim brought by employer co, because that was a factor in John Doyle at paragraph 110. That was one of the reasons for holding the ATE policy in that case was inadequate. Then there's a limit of 1 million. And of course, you need to know what that million covers, because if it, for example, overlaps with the enforcement sum, you might think that's wonderful at the start, but then you think, well, but the £350,000 is biting into that 1 million. You then have to ask how much it would cost to bring your proceedings. At the very least, you probably should take a leaf out of Mr. Justice Waxman's book in the Aztec case, where he made clear that the court order gave the responding party liberty to apply for an increase to the amount to be covered by the ATE policy. And thinking about that, you might want to ask for confirmation that the insurer will comply with such an order if given. They might say, no, 1 million is our limit and that's that. which case that's a point to be taken at the start. Then we have the lien, as I mentioned before, that seems to conflict potentially with the offer of ring fencing. So that's reason to argue that the arrangements are inadequate and the lien should either be removed or that enforcement should not be ordered. And that's a point that was taken, as I mentioned, in John Doyle successfully. If calculus contends that there's no difficulty, because calculus contends that it's the party that's going to be repaying the amount after deduction of the lien, that really emphasizes the importance of ascertaining calculus's financial standing. Is it actually good for that sort of commitment? Exclusion and avoidance clauses, there's a lot to be said to be found in John Doyle about that. And there's a good quote to have if you're defending an enforcement application at paragraph 107. The absence of anti-avoidance provisions and the presence of avoidance clauses will normally mean that AT cover, which includes such terms, is not adequate security. So have that in mind and then go through the factors. One of the questions is that one of the points that's often made by the funder is, well, we're all reputable people and we're all going to act in a reputable way. But in the Premier Motor Auctions case, the point was already made. Well, they might be reputable, but insurers do avoid their policies. So the second point, as they put it, is that the party resisting enforcement must be entitled to some assurance that the insurance was not liable to be avoided for misrepresentation or non-disclosure. Do you have the placing information? It may not have been provided by Sparky. It may have been provided by Calculus. If so, how do we know that they've given correct information to the insurer? Is the insurer going to turn around and say, well, if we'd known that, then we wouldn't have placed the cover? Even if you have the placing information and you want to ask for it, it may not be enough, and that's a point that you'll find in John Doyle. What are the termination provisions? Sometimes there are termination provisions by which the insurer can say, if we decide that Sparky in this case is going to lose, then we can terminate cover. Well, that was a point that was live in John Doyle. And of course, it's not surprising to hear that that was a reason that the cover was held to be inadequate, because it's precisely in circumstances in which Sparky is going to have to repay the money that you wanted that obligation to be covered by insurance. So from the point of view of employer code, you probably want to argue that exclusions be removed, and on the contrary, that there should be an anti-avoidance provision. And if you want to find some language that you can play with, look for the decision in Geophysical Service Centre, which is referred to both by Mr. Justice Fraser and in the Premier Motor Auctions case, and you'll find there a nice little appendix which gives you an instance of such a provision.
We always need language we can play with. Thanks for that. Let's just take stock at where we are at the moment, because we've gone through the first three questions. My reading is that we've applied the 3 or is it 5 principles. David, aren't we going to get pushback from the finance director of Employer Co? That's who we're advising. He's going to say, this is all very well, but this is going to cost me a huge amount of money, a huge amount of time, neither of which I have. I'm going to stir up a hornet's nest. You're telling me to go away and look at this problem with the retail park. Can't I just leave it alone?
It's going to be very attractive to do that, particularly in respect of Retail Park 1, is to let Sparky do all the running, set out all the conditions. But I think 2 points arise from that. And they emerge from a point, but insolvency set-off is the best defense they have of getting maximum value for any claims they might have. Because if they simply go in as unsecured creditors seeking to bring a claim, they'll be standing pari passu with all the other unsecured creditors in the back of a line, trying to get some money out of a company that's probably not worth powder and shot. Well, the best way to get value out of these potential cross claims in respect of the Retail Parks 1 and 2 is to set them off against what looks like is probably a good claim in respect of Retail Park 3. So this way, they're actually using insolvency set-off and what's been recognised down the years as being an extremely valuable tool when dealing with insolvent companies. And in any case, as I've alluded to before, there are potential limitation issues with respect to Retail Park 1, depending on how that contract was entered into. But they are going to have to get their skates on in respect of Retail Park 1, because I don't think the TCC is going to be terribly impressed at the suggestion now at the enforcement hearing we might have a claim it might be against Sparky. They're going to want to see a lot more than that, otherwise you get a very dusty response. And that was actually put in debate by council in Bresco. The idea that you could allude to there being a very small set-off, and that therefore being able to defeat a claim for summary judgment by way of effectively raising the spectre of insolvency set-off, and hence the Dow Jensen case, and that was quickly rejected. So I think you're going to want to see, you're going to have to do some investigations, and in the long run, it's going to be the best value for employer code to get the best value out of their claims, Marion.
Thank you for that. Can I just say to the people who are listening in, please do submit questions through the Q&A box. We are monitoring that. We'll do our best to pick them up, and if not in this, we'll try and follow up afterwards by email. We are picking up some of the questions that are pre-submitted, and I think that, John, you've been doing some work looking at the extent to which, because everything we're talking about is insolvent companies, and you had a quick look. You were sharing some thoughts with us about the wider application of this approach.
Yes, and just to pick up on David's point, in the John Doyle case itself, you'll see Mr. Justice Fraser dealing quite briskly with a point about the set-off value, and the court was moving on that point like a bulldozer. So don't assume that you can trail a potential claim. You do need to do better than that. Yes, the question will be, well, this is all very good for insolvent liquidation, but what's the impact for other types of financial difficulty? And the first general point is that you always have what's called the Wimbledon and Vago point, which is a stay of execution point, and you may be hearing more about that from others. So I won't say more about that generally, but always be aware that the reason why you have the situation in insolvent liquidation is what used to be Rule 4.19, now 4.16, and the insolvency set-off that David has referred to. The question is, well, do you have the same sort of situation more generally? I mean, it can depend on the terms. So, for example, there's a CVA case, Creditors Voluntary Administration situation, called West Shield and White House, decision by Mr. Justice Aikenhead. So you can work out, if you're an expert, how long ago that would have been. And in that case, the terms of the CVA seem to mirror those of the insolvency rules in respect of set-off. And in that case, therefore, the CVA was treated as being equivalent to as insolvent liquidation. So you have the same situation as you'd have now on the cases that we've discussed. Second, more generally, in terms of administration, there's a decision by Mr. Justice Edward Stewart in a case called straw realizations. That may ring a bell for some participants. And in straw realizations, there's a rather sense that administration might be treated the same as liquidation, but that isn't necessarily going to be the case. So I think it really comes down to what the financial situation of the party that's seeking to enforce really does look like.
Yes, well, let's move on to the fourth question that we ask, which is in relation to the impact of the agreement that must exist between Sparky and its probably we talked about gut feeling at the beginning of this, and let me lay it on the table at the moment. My gut feeling on this is we need to monitor very carefully how much time and money we invest in looking into this. It was the winner in Meadowside. The argument was run that the agreement between the claiming party and its funder was shampitous, so as to be an abuse of the process, and in those circumstances, it was inappropriate to allow the claiming company to take advantage of an exception to the approach and to be able to enforce against an insolvent company. That argument won in Meadowside largely because the funding agreement was not put into evidence. Judge said, quite frankly, I cannot rule out the possibility that this is an abuse of the process. And I think that lesson has probably been very clearly learnt and absorbed. And certainly if you look at Erith, it seems to me, well, it's quite clear that both of the aspects of the funding agreement, round 1 and round 2, were in play, were considered. And it's also worth noting that the judge did not decide. He talked about a rich and varied landscape, but he didn't need to go to it because the big issue was John's issue and the adequacy of the security for the sum that was going to be paid over pursuant to the adjudication award. So against that backdrop, I think we need to be quite careful. It also, you may want to build up the tension and the heat between the parties. It will do it. In Erith, as the judge said, umbrage was taken at suggestions that there was misconduct or perhaps fancy footwork is a more neutral way to put it. So if you're going to want to take the point, let me just flag this up. It was taken on the basis, and you've got all the signs in the problem, that there is potentially the scope because you've got a 40% payout. That is what the funders will retain of any damages that are awarded. David has been deliberately vague as to quite how that sum is to be calculated. We will all be aware that the cutoff for a damages-based agreement that is subject to regulation for these sorts of claims is 50%. But how you calculate it is a matter for debate. Now, it also, and the key question will be, what are the services that the funder, as I loosely call them, are providing? The claims consultant funder in Meadowside was regarded as being plainly providing services that were caught by the damages-based agreement, and they weren't complying with the restrictions that had then imposed. 18 days later, in the Competition Appeals Tribunal, another High Court judge in UK truck claims and Fiat Chrysler automotives, looking at a third-party litigation funder, said they weren't providing claims management services. So we can see as a team that there is scope for extensive argument once you've got the terms of the agreement in place. If you do establish that it is a damages-based agreement, and if you establish that it doesn't comply with the restrictions that the relevant legislation imposes, or if you just prove that it's shampootus, you've still got to go that next stage and prove that it's an abuse of the process, which is, as lawyers love to say, a highly fact-sensitive question. So that, I think, is enough of it. My gut says we'll look at it, we're not going to drop it, but we're not going to spend a huge amount of money. Rebecca, what are we going to do if we fall back on a stay?
So the relevant part of the CPR dealing with a stay is part 50, and the principles relating to the operation of part 50 are those famously set out in Wimbledon Construction Company and Derek Vago, which goes back to 2005, but is still the leading case on award of a stay. Peter Coulson was the judge for that case, and he said that a stay should only be awarded in special circumstances. And he specifically considered in that case the stay of an adjudicator's decision because of the receiving party's financial position, and listed at paragraph 26, 6 relevant principles. Said first of all that adjudication is designed to be a quick and inexpensive method of arriving at a temporary result in a construction dispute. Now, question of course whether that statement after the decision in Erith is quite as accurate, because obviously Erith focused on adjudication being more of a final decision in practice than it was originally intended to be. But that's still principle number 1. And secondly, in consequence, adjudicators' decisions are intended to be enforced summarily, and the claimant, being the successful party in the adjudication, should not generally be kept out of its money. Now, that principle still remains. Thirdly, in an application to stay the execution of summary judgment arising out of an adjudicator's decision, the court must exercise its discretion, so mandatory, it must do so, with considerations A and B firmly in mind. 4, the probable inability of the claimant in the enforcement action to repay the judgment sum awarded by the adjudicator and enforced by way of summary judgment at the end of the trial or arbitration hearing may constitute special circumstances rendering it appropriate to grant a stay. But stronger than that, if the claimant is in insolvent liquidation, as is the case with Sparky here, or if there's no dispute on the evidence that the claimant is in fact insolvent, then a stay of execution will usually be granted. So that's the starting point we have with Sparky. Because Sparky is an insolvent liquidation, a stay of execution will normally be granted, obviously subject to the court's discretion. However, that is subject to the sixth principle, which is this: even if the evidence of the claimant's present financial position suggests it is probable it will be unable to repay the judgment sum when it fell due, that would not usually justify the grant of a stay in two separate circumstances. Either the claimant's financial position is the same or similar to its financial position at the time that the relevant contract was made. And that's clearly on the basis that the party contracting with that party either knew or should have known, if it had done its due diligence, of the financial circumstances of the claimant, and maybe it's chosen to take that risk. The second option is this: if the claimant's financial position is due either wholly or in significant part to the defendant's failure to pay those sums which were awarded by the adjudicator. And that's clearly fair. The defendant can't have its cake and eat it too. So going back to the position of Sparky, Sparky is an insolvent liquidation, so a stay of execution would normally be granted. Do either of the exceptions apply? Well, looking at Sparky's financial position, we don't know whether it's the same or similar to its financial position at the time the relevant contract was made. It wasn't in liquidation when it entered into the contract, but that doesn't necessarily mean it wasn't insolvent in practice, even if it hadn't entered formal proceedings. And this might be something that Employer Co was aware of. It was in contract with it already. It might have had conversations with it about payment or about its financial position. We don't know. We'd have to ask Sparky for all the relevant accounts for that time. Secondly, is the financial position due in whole or in part to Employer Co's failure to pay Sparky the money due under the adjudication? Well, in terms of timing, it went into insolvent liquidation in 2017, the same year that the dispute arose. So you would have to seek more information from Sparky as to its accounts, but it certainly looks arguable that the exception would apply, which would mean that a stay wouldn't be granted, but it's certainly something we'd have to have more information from Sparky to work out what the position would be from the judge.
So we are coming up, unfortunately, with a list of questions, aren't we? Further work to be done. Let's just pick up on a couple of questions that have come into the question box. David, this one: if summary judgment to enforce is refused, is it open to Sparky to commence a fresh, separate summary judgment application to enforce the same adjudication decision on different grounds, likely with amended security arrangements?
I think it depends on whether we're looking at it being defeated at the summary judgment stage or if it's a stay stage, and if it's simply a case of there being an actual change of circumstances. So, for example, if it's at the stay stage and you're relying on solvency set off, but those other disputes now fallen away, they've been proven or they haven't been proven in the insolvency, and there's a complete change of circumstances, you may want to come back. I think the TCC is going to give you a very hard response if you just simply chip in with a slightly amended ATE policy of insurance and a few tweaked conditions. I think they're going to tell you to go away. Better is what they did in Bester in Balfour Beatty and Aztec, where they had the ATE insurer actually in court, who was ready and willing to listen to what the TCC judge, Mr. Justice Waxman, was actually saying. If it's stay, and we're at the stay stage, but there's a real issue. Again, if you're looking at a change of circumstances, that might well be something you can put forward. But I don't think simply playing around with the conditions is going to let you get home. You should put your best arguments forward first at that point in time.
Two more questions, because we're right up against time. One for John, one for Rebecca. John, you talked about ring fencing. Can you get any practical help on what is meant by ring fencing?
Well, generally you'd expect the liquidator to set up a separate account. And the question would be, in this case, what are the arrangements, and how, in this case, because of the lien point, how are they distinct from the insurer's lien, such that this money really is being ring-fenced with only an Employer Co as the beneficiary? It might be that one thing you'd want to do is to have some provision that money could only be paid out by order of the court, let's say. You know, you might try to link it in that way. And so that the court has to decide whether the money is paid out, and the court can then decide what to do about the lien point. Just one point, if I can, about the enforcement point. I think David was completely right. Remember, of course, that if you are not given enforcement, so you're not at the enforcement but stay, then actually the proceedings aren't dead. You have your claim, you just haven't got summary judgment on it. So the question would then be, you told it off to trial. And I think there's at least one implicit in one apparent bias case where that actually happened and it went on to trial. I think maybe Discane, one of those cases, actually went all the way. So you can imagine all the evidence. I think you'd be in a horrible situation because the question would then be whether there are forms of issue estoppel and so on in respect of the judgment if you try to re-argue the same points. But if you do try to drop these proceedings and then, as the question I think puts it, commence a fresh separate application, there's also an abusive process argument. That unless you that you should have done all this first time around. So I wouldn't suggest you do that.
Okay, well, let's, Rebecca, we're right up on the time. Let's take the first question that came in. Is not the Supreme Court's decision in Bresco and the TCC in John Doyle a work creation scheme for no win, no fee claims consultants and highly paid adjudicators? In short, says the questioner, who is anonymous, Coulson, Lord Justice Coulson, hello Lord Justice Coulson, was spot on when describing such claims as an exercise in futility.
I don't think it necessarily is. I think with adjudications, whether or not the adjudicator is highly paid or not, they still have to be paid whether or not the decision is enforced. If you have an adjudication, unless and until it's held that it's not enforceable, the adjudicator has to be paid. So they're going to have the same amount of adjudications, whether or not, same amount of payment, I should say, whether or not it's enforced in court. So I don't think I'd agree with that.
I just think we need to be aware of the reality of life as we move into lockdown 2. There is going to be such limited money available that any form of dispute resolution is going to be a luxury, and adjudication is known for being quick and cheap, and it's one the industry likes. So I think it will continue to use it. It wanted to use it, and we're just going to see settlements flowing from it. Let's see.
I'll just add to that as well, that adjudication is really made for lockdown. I mean, I've done a number of hearings in court during this extended lockdown period, and they've been fine, but some clients will view them as not being the same as usual court proceedings. And a lot of my cases that would normally have proceeded to court because they're higher value have gone to adjudication instead because there's no change in procedure, and clients feel more confident, I think, that they're undergoing exactly the same procedure as they would do if it wasn't a lockdown. So I've seen more of a shift to adjudication as well.
John, David, one sentence each on that.
I agree.
I would agree, and I would say there's going to be a lot of insolvency arising out of this, and insolvency practitioners are going to be looking to ways to prove debts in the insolvency and secure realization for their creditors, as they are obliged to do. And this is one option for them. Even if we don't necessarily go down the funding route, then liquidators with nous and some money behind them might think that for good claims, but this gives them a very realistic prospect of getting some better distribution for their creditors.
Yeah, well, on that rather sobering note, but I think very realistic, thank you very much for joining us. We've enjoyed the debate. The questions that we've not been able to answer, we will attempt to come back to through email. Thank you very much.